Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got.
What happens when the very people called to de-escalate a situation become the ones who escalate it? Today, we're diving into the case of Michael Jones, a man facing 6 months in jail for interfering with a public servant. The police report paints a picture of a non-compliant and aggressive suspect, resisting arrest. But his lawyer claims the police had no right to stop him in the first place, calling their entire case fruit of the poisonous tree. This is a masterclass in courtroom strategy, where one question will decide everything. Did the police overstep their authority? Let's break it down.
Door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not.
Okay, let's pause here because the charge itself is critical. Interference with the duties of a public servant is a serious accusation. It essentially means obstructing or preventing an officer from lawfully doing their job. The key word here is lawfully. The entire case hinges on whether the officers were acting within their legal rights when they tried to detain Mr. Jones. The defense is challenging probable cause, which is the legal standard police need to make an arrest or a search. They're arguing from the very beginning that the police lacked a legitimate reason to stop him, making everything that happened afterward illegal. The stakes are high. 6 months in jail and a
Go
hefty
forward or
fine.
not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
Did everyone just catch that? Even the judge is pointing out the massive contradiction. The police were called to the scene because Mr. Jones was allegedly refusing to leave a residence. But the second the officers arrived, the report says he began to walk away. He was literally doing what the resident wanted and what the police were there to enforce. Yet, at that exact moment, they command him to put his hands behind his back. This is the pivotal moment of the entire case. If he's complying by leaving, what crime is he committing that justifies them stopping him? It looks less like he was interfering with their duties, and more like they were interfering with his departure. What do you guys think? Let me know in the comments if you think the officers had a reason to stop him here.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No. Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then
Right, but then cops get up there.
and then they observed him begin to walk away. And it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know
says
about that?
and
Yes,
aggressive
Judge.
behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. I smell marijuana. You look intoxicated, because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police, so what? Everything that happens after that is fruit of the poisonous tree.
Fruit of the poisonous tree. That is a brilliant and powerful legal argument. For anyone unfamiliar, it's a doctrine that says any evidence obtained from an illegal arrest or search is inadmissible in court. The tree is the illegal stop, and the fruit is everything that came from it. The struggle, the resistance, the arrest itself. The defense lawyer is arguing that since the police had no lawful reason to detain Mr. Jones as he was walking away, the entire chain of events is tainted. You can't charge someone for resisting an unlawful arrest. This argument completely flips the script. It's no longer about whether Mr. Jones resisted. It's about whether the police created the situation by violating his rights in the first place. This is a bold legal checkmate move.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only.
right? So it's like adding fuel to a fire.
But they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw, him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Here comes the counter-argument from the prosecution. Their position is that just because a suspect starts to comply when police arrive doesn't mean a crime didn't already occur. They're saying the officers still had a duty to investigate the initial disturbance call, the alleged trespassing and yelling. They're also leaning on the public intoxication claim as a separate reason to detain and investigate. This is a classic clash we see in courtrooms. Individual liberty versus police authority. The defense says he had the right to walk away. The prosecution says they had the right to investigate what they were called for. It's a fascinating legal gray area, and the judge has to decide where that line is drawn. Whose argument are you buying at this point? Defense or prosecution?
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
And there it is. No probable cause. That is a massive win for the defense and a complete shutdown of the state's case. By saying this, The judge is officially ruling that the police did not have a sufficient legal reason to stop and arrest Michael Jones. The judge agreed that once Mr. Jones started walking away, the initial reason for police call, the trespass, was resolved. Any attempt to stop him after that point was an overreach of their authority. This ruling validates the fruit of the poisonous tree argument entirely. The case is over before it even began. Mr. Jones is walking free because the judge recognized that citizens have a right to leave a situation, especially when they are already complying with what was
Probable
asked of
cause.
them.
We understand.
Mr. Jones, be careful, man. We have enough drama in this life, don't we?
Yeah.
You don't like to wear orange, do you? Be careful where you go. Be careful what you do.
Sir.
Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
I
Thank
didn't
you,
hear what happened.
So, to wrap this all up, the case against Michael Jones for interfering with a public servant was dismissed entirely. The core issue wasn't his actions during the arrest, but the legality of the police stop itself. The prosecution argued they had a duty to investigate a disturbance, but the defense brilliantly countered that this duty ended the moment Mr. Jones began complying by leaving the scene. The judge's no probable cause finding is a crucial affirmation of a citizen's rights. It sends a clear message. The police cannot use a resolved situation as a pretext to initiate a new confrontation, especially when their intervention only serves to escalate it. This was a textbook example of a sharp defense dismantling a case by attacking its very foundation. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.